Whoever hearing in the appeal or wishes to make Thomas Ltd against and 3 others against Emtel Ltd.
Yes, Mr. Case. My lords, my ladies, if I can then turn to my submissions in relation to period 1. And I'll start, if I may, by taking the board to the first instance judgment. And just to set the scene, what I propose to demonstrate in doing so is that firstly the Court of Appeal was correct, and to say that the judge made no finding of any acte fautif in relation to period 1. Secondly, indeed, that the judge didn't discern any such cases being advanced. And then thirdly, to show you what the judge did say about period 1 and where we say she went wrong. So if I can start at the very beginning at page 2698. In paragraph 1. You see the judge introduces her judgment by saying the present claim for damages for unfair competition under Article 1382 arises from an alleged breach of licence conditions. Now, I think you were taken to some of this yesterday, but just to remind you of what she then did say about period 1, starting at page 2714. Or rather 2713, para 63. It's certainly right to say that she records that Emtel contended that Cellplus was operating GSM services before the end of its exclusivity period, and then at B, Cellplus started commercial operations before its license date. And that Emtel says that caused it to suffer a loss in market share. And then she deals with that in more detail at 2715. And 67 to 72. And reaches the conclusion, for the reasons that she gives there at 72, that indeed Cellplus did start commercial services before the issue of its license. And that, of course, was a finding that Cellplus, against which Cellplus appealed, and which the Court of Appeal didn't deal with. But it's certainly right to say that as far as the judge was approaching the case, she came to that conclusion. Then if I can go through, please, to page 2732. Starting at para 149. You see here that the judge is dealing with some evidence from Mr. Thomas.
Looking at the heading, this seems to be about period 2.
Well, my lord, yes, but when I come to the paragraph on the following page, you'll see why.
Okay.
Why I raise this.
I'm just trying to set 149 in its context.
Yes. So we don't need to trouble ourselves too much about the detail of what she says at 149, 150. She's talking about Mr. Thomas's evidence. He's drawing on his experience as a past director of competition at Ofcom. And over the page of 2733, she summarizes what Mr. Thomas's conclusion is, as you see in the words in italics. And then she says, in my view, this specific conclusion of Mr. Thomas is not relevant to the present case, which is based on a breach of license conditions which prohibit cross-subsidization. And then she makes similar points at 152, 153, now moving on to Mr. Forrest's evidence. He was Emtel's expert. And so you see at 152, Mr. Forrest is emphatically of the view that essentially the material referred to by Mr. Thomas is not relevant, and at 153, this is because the claim of Emtel is for breach of the licence conditions by CellPlus, and the failure of the TA to ensure that the licence conditions be complied with in accordance with its duties under the 1988 Act.
I'm not, for myself, quite sure what we're getting from this, because as Lord Briggs has pointed out, this is addressing the second period.
Well, my lord, it is, but as I work through the judgment, you'll see that when the judge is dealing with questions of Act for TEEF, she only ever talks about breach of licence conditions. And it's apparent that, as the Court of Appeal observed, the only Act for TEEF in relation to which she makes a finding is breach of licence conditions.
Well, except that you've just shown us paragraphs in which she makes a finding that there was trading without a licence.
Well, my lord, she makes a finding of fact. What she doesn't do is to say, and Emtel's case about this period is not based on breach of licence conditions. It's based on operating without a licence, offering free calls, whatever it might be. Obviously, the breach of licence conditions is a case which runs as from September onwards. Wasn't said and can't be said that
But she makes a finding at 72 that CellPlus was not testing the service, it was operating commercial services before it obtained its licence.
My lady, she certainly does. But what she doesn't do, and we'll see what the Court of Appeal says about this, what she doesn't do is to say, and operating without a licence amounts to fault. And it's actually clear that,
obvious.
Yes.
well, my lady, no, not at all. Not at all. We said, and we say, operating without a licence might give rise to criminal liability, it might give rise to action by prosecuting authorities. What it doesn't do is translate into a cause of action belonging to a competitor.
Even where it's operating without a licence and charging a zero tariff?
My lady, yes. What would translate into a cause of action belonging to a competitor would be if you fall foul of the jurisprudence that I briefly referred to yesterday, and you're getting into predatory pricing and so on.
If trading in breach of a licence condition is fault, one might have thought that trading without a licence at all would be a fortiori.
Well, of course, we said also that trading in breach of a licence condition is not fault. That was and is a matter of dispute.
But we were shown yesterday the judge accepts, I think, Emtel's expert evidence that the correct counterfactual for the purposes of period 1 was that Emtel was doing 100% of the trading. So her thought process must have been it was a relevant wrong sounding in damages that CellPlus were trading at all during period 1.
Well, my lord, we'll come to look at it in a moment, but in my submission, what the judge moves on to say is that in relation to the claim period, namely September or November 96 onwards, the effect of CellPlus having moved into the market earlier than it should have done is that we need to adjust the counterfactual for the claim arising from the claim period. And I'll take my lord in a moment to the passage of the judgment where you see that reasoning. And so as far as we've got thus far, what we have not seen is the judge saying trading without a licence equals fault for the purposes of Article 1382. And we'll see that the Court of Appeal took the very clear view that can't be said. I'll take my lords and ladies to the Court of Appeal judgment next. But the Court of Appeal were very clearly of the view that there's no such conclusion that follows, as it were, without more.
But is the question whether trading without a licence constitutes fault at all a question for this appeal? I thought the issue on period 1 was a different one, namely whether a licence can be backdated and matters arising from that.
Well, that certainly arises, but when we look at the Court of Appeal judgment, we'll see in my submission the Court of Appeal, there were three strands to the reasoning of the Court of Appeal in relation to period 1. Firstly, that Emtel had pleaded no case, that there was some distinct fault in period 1 arising out of trading without a licence. Secondly, that the judge had made no finding of act fautif. And thirdly, the retrospectivity clause. So if I can then take you to the passage which we say shows the judge perceived the evidence in relation to period 1 as affecting the counterfactual to be applied in assessing damages in relation to period 2. If we can start at 2742. So para 191. You see the judge says, to calculate Emtel's loss, Mr. Forrest assesses the difference between the revenue that Emtel would have earned had CellPlus not breached the conditions of its licence, and therefore in Emtel's contention would have been compelled to charge reasonable tariffs, and the revenue that Emtel actually earned during the claim period, i.e. November 96 to 2002. And then Mr. Forrest draws up a counterfactual alternative scenario of reasonable tariffs, central to his calculation of loss of tariff income.
But from there to paragraph 210 is all about period 2, isn't it? You get to period 1 at paragraph 211 on page 2747.
You do.
Emtel also contends that it traded without a licence.
My lord, yes. But what we say is significant is in paragraph 211 on page 2747, starting at the penultimate line, this loss of market share, which started in March 96 but continued after CellPlus obtained its licence, in Mr. Forrest's view, impacts on the counterfactual case.
Sure.
What we submit she's referring to there is the counterfactual that she's referred to above, namely the counterfactual to be applied in assessing damages for the breach of licence conditions.
But she goes on to say, thus, in the counterfactual case, during the period of March to September, the market share is assumed to be 100%.
Yes. So what we say she does is that she says when assessing damages that flow from the act fautif that she does find, she should assume, contrary to the actual facts, that at the start of the claim period, Emtel had a 100% market share. And it seems to be on the footing that under the principles applicable to assessment of damages, under Mauritian law, some principle along the lines that that's the just way to do it. CellPlus shouldn't be able to benefit from its actions in entering the market more quickly than it should have done. What, in my submission, she's saying here is that that's how the market share loss case is relevant to the assessment of damages flowing from the breach of licence conditions. And then it becomes clearer, my lords and ladies, if we go to page 2752, para 232. Under the heading Emtel's cause of action. And you see it said that Emtel pleads foot against the 4 defendants, although the breaches constitutive of the foot alleged quo ad each of the 4 defendants are different. TA failed in its duty to ensure that the conditions of the licence granted to CellPlus were complied with. As regards MT and CellPlus, they breached the conditions of the GSM licence and engaged in unfair competition, resulting in damages to Emtel. So again, under the broad heading, Emtel's cause of action, nothing to say. There was also fault in period 1. through operating without a licence.
Well, isn't engaging in unfair competition by operating without a licence on a zero tariff?
Well, my lady, in our submission, and there's a specific reason I say this, but in our submission, what she's saying here is that they breached the conditions of the GSM licence and thereby.
Well, she doesn't say thereby.
No, but when I've taken my lady through the totality of the judgment, you'll see that although she carefully addresses Act Furtif when it comes to period 2, she never does so in relation to period 1.
So you say this is just directed at period 2?
Yes, she perceives the claim period to be what we're calling period 2. She says the relevance of the evidence.
She doesn't, because at paragraph 63, she set out in clear terms a distinct claim that Emtel is making.
Well, my lord,
in relation to period 1. I mean, insofar as we're looking at construing the judgment, surely you have to read 232 against the backdrop of 63 as well.
Well, my lord, at 63, she's saying, as it were, Emtel makes the following contentions, 1, 2.
But not only that, 211 identifies 2 separate periods, and Mr. Forrest's calculations being in relation to 2 separate periods.
My lady, it does. But in our submission, when you look at the judgment and you look at the way the judge addresses Act Furtif specifically, she deals only with period 2.
But that's not binding on the Court of Appeal. That's a legal thing, isn't it? It's not a factual finding. Why does it matter? You seem to be accepting that this was put forward by the claimant, but she didn't deal with it, you say. That's a matter of construing the judgment. But given that she made the factual findings, why does it matter whether or not she actually expressed a legal conclusion as to the nature of those?
Well, my lady, we don't accept that Emtel advanced a separate case of faute in relation to period 1 at trial.
Really?
We don't. I'll take the board in due course to some references in Emtel's submissions at trial, where you see that, in fact, they mirror what happened here. When Emtel deals with liability, it deals only with breach of license conditions. Then, under quantum, it addresses some submissions about period 1. And, my lady, the other point...
Forgive me, I mean, just on that, I mean, wasn't it clear that Emtel were claiming damages in relation to the first period? So they were asserting a cause of action in relation to the first period. Was that not clear?
My lord, we say no. And we say,
They weren't claiming
that was the
damages for the
judgment of the
first
Court of Appeal.
All right, okay.
But they weren't claiming from March 96.
That they had asserted no claim under Article 1382 in relation to period 1.
So what were they saying about period 1? Why were they even mentioning it if they weren't asserting a 1382 claim?
In my submission, what they were saying was essentially this. Our claim arises from breach of license conditions, and that Act Furtif, started in September 96. However, in assessing damages for that claim, you should bear in mind that CellPlus had come onto the market sooner than it should have done. And so by the time the claim period starts, some adjustment needs to be made to the counterfactual to allow for that fact. CellPlus shouldn't be allowed to benefit from having come onto the market sooner than it should have done.
But were they claiming damages for loss of business to them in that first period?
Well, my lord, according to the Court of Appeal, not in any adequate way.
But it doesn't matter what the Court of Appeal said. It's a matter of construing the pleading, isn't it?
Well, my lady,
The
I'll
pleading
come to that.
identifies a claim in respect of period 1.
Well, in my submission, it doesn't. But there's another point, which is what we're really dealing with here, is how must a plaintiff go about adequately pleading a case of act fautif under Article 1382.
Well, that's why I asked my question, because I wanted to take it in stages. Was there even a claim for damages in relation to period 1? I have to say, I rather had the impression that there was, but you say not, and we'll leave that to when you come on to the pleadings. You're going to show us that there wasn't. But if there was, then isn't it obvious that Emtel was asserting a cause of action in relation to that? They could only claim damages if they were asserting a cause of action.
Well, no doubt, if correctly construed, it's clear that they were claiming damages on some basis not tied to breach of licence conditions, period 1, and then they must have been implicitly asserting that there was a cause of action.
Yes, and if they were implicitly asserting that, and everyone recognised that the relevant principles involved there being, if you wanted a cause of action, you had to have an act fautif for the purposes of Article 1382, wasn't it necessarily implicit? I appreciate you're going to show us that they weren't claiming damages, but if they were, wasn't it necessarily implicit that their argumentation in relation to act fautif in relation to period 2 also covered, necessarily, act fautif in relation to period 1?
Well, my Lord, in my submission, no. And we're getting into territory here which we say is best left to the judgment of the local courts. So we'll see that the Court of Appeal very clearly said there we can simply discern no pleaded case of act fautif in relation to period 1. That's part of the ratio of the Court of Appeal in relation to its judgment on period 1.
Right, but they might just have made a mistake about that.
Well, my Lord, they might have done, but in a sense, who's to say? This isn't really a matter of English pleading practice. We're dealing here with a cause of action and
I mean, the point I'm seeking to put to you isn't so much a matter of pleading practice, but a matter of logic. If there is a claim for damages in period 1, it's just as a matter of logic. Legal theory demands that you must be asserting a cause of action in order to justify your claim for damages. That's the point I'm putting to you. And since the only cause of action anyone's talked about at all involves act fautif under, for the purposes of Article 1382, if there is a claim for damages in the first period, it just seems to me it must necessarily have been part of Emtel's case that there was act fautif in period 1.
well, if it's right that the damages were separately claimed in relation to period 1, then no doubt it must have been that could only be on the footing that there was an allegation that there had been an act fautif.
Yes, I think that's all that I was putting to you.
Yes, but whether that's an adequate way of pleading a claim under Article 1382, and quite how specific you have to be about the act fautif that you allege, is a different question. And we'll see that the Court of Appeal very clearly took the view that there was no properly pleaded claim of act fautif in relation to period 1.
I have rattling around in the back of my head something I learnt at bar school, which is you plead facts and not law.
Yeah.
Is there some different rule under French law, and is it French law of pleadings that applies in Mauritius? The pleadings look awfully English to me.
Well, the pleadings are in English, but the provision being invoked is obviously French in its origin. I would need to take some assistance on what the rules of pleading in relation to Article 1382 and Act fautif say and where they derive from. My point is that the Court of Appeal, one should assume, would be pretty familiar with that sort of thing.
Yes, but we're hearing an appeal from the Court of Appeal.
Yes.
The appellant fairly and squarely says we were not deficient in our pleadings in relation to period 1, and they've taken us to where trading without a license is pleaded as a fact. You say, yes, but they didn't set out the law, which turns that fact into a cause of action. So I'm asking you, are there some French rules of pleading which, unlike ours, say you have to plead all the law out as well as the facts?
Well, my Lord, I'm not sure it's so much as a question of pleading the law out as actually asserting, identifying the act fautif upon which you rely.
Well, the act fautif is trading without a license.
But it wasn't identified as an act fautif.
Oh, this is... Well, we hear what you say. We've been taken to 11.1 in the pleadings, and we've been taken, which is the in the narrative of facts and deals with the period, the first period, and then we've been taken to 17, which avers that the acts of MT and Cell Plus constitute faute and are tortious. And there we are.
My Lord, yes. Well, I'll take the rest of it quickly, but there is a separate point, which is that the Court of Appeal, another basis on which the Court of Appeal allowed the appeal was that the judge had made no finding of act fautif in relation to period 1. So if I can move away from the pleadings and just take you to some passages that make that good. Starting at page 2762. And para 277. So here we see an express finding of act fautif in relation to the alleged breach of license conditions. There is no equivalent finding in relation to some faute said to arise from operating without a license or offering calls for free. And then if I can take it through to 277.
Just to observe, the paragraph you were just showing us is under the heading on the previous page, has Cell Plus benefited from cross-subsidisation from MT. So,
Yes.
I mean, the judge's focus there is very specifically upon the second period.
Well, I agree, but the point that we make is that there you see an express clear finding of act fautif arising from breach of license conditions. There is no equivalent finding in relation to operating without a license or offering calls for free.
But if they're offering calls for free, they must be being cross-subsidised by their parent.
Well, my lady, no doubt, but of course that was at a time before the alleged license conditions had come into being. The alleged license conditions are said to arise from the press release or the letter of 5th of September.
But your case is that the licence was backdated,
Yes.
but it had still conditions as to what they had to charge. So on your case, weren't they also actually in breach of those licence conditions right back to March 1996?
Well, my lady, no. I'll come to that. But
Okay.
in a nutshell, we say that it's possible for an act to confer on a public authority the ability retrospectively to render lawful something which was unlawful at the time.
Are you saying it's possible or impossible?
It's possible for that to happen, but it's not possible for an act to confer on a public authority the ability retrospectively to render unlawful something which was lawful when done.
But what if it was unlawful at the time?
Yes.
And is rendered lawful only subject to conditions which weren't complied with? I think the case being run against you is that it remains completely unlawful. But an alternative case, I think, is that it was lawful but in breach of condition.
My Lord, I understand. I'll come back to it, but in my submission, the theory doesn't work.
I'm sorry to press you on this. I'm now just wanted to pursue the point made by my Lord Reed that why doesn't the finding of faute in relation to trading in breach of license conditions not necessarily cover trading where you don't have a license at all? I mean, that's the more egregious form of unlawful activity.
Well, my Lord, it was Cell Plus's case, and remains Cell Plus's case, that trading in breach of license conditions is nothing to the point when it comes to a claim by a competitor under Article 1382.
Right, but they lost that argument, didn't they?
Well, my lord, they lost it in front of the judge, and the Court of Appeal didn't deal with it. Because what the Court of Appeal did was to say, well, essentially there appear to be two strands to Emtel's argument. One is that breach of a license condition without more amounts to foot, and two, that what Emtel rely on were indeed conditions of Cell Plus license. And the Court of Appeal disposed of the appeal on the second of those points and said, well, the alleged conditions were not conditions of the license. Ergo, the argument fails.
Right. So the appeal comes to us on the basis that, as the judge found, I appreciate there may be debate about this later on, breach of license conditions does constitute default.
She certainly found that.
Right. And there's no appeal that's been allowed on that point thus far.
My lord, correct.
So I think, I'm just trying to follow through the logic then. So I think that we address the position on the basis, is this not right? That breach of license conditions is an act fautif.
Well, my lord, I'm not sure about that, because that falls fairly and squarely within the body of untreated issues in relation to
all right, put brackets afterwards.
Brackets, yeah.
Subject to later debate, but it's not an issue in controversy before us.
Entirely so.
Right. So
the question in relation to that part of the case is, as it were, the short question addressed by the Court of Appeal, were these alleged conditions or were they not conditions of the licence?
Yes, absolutely. But then one comes back to the logic of the case in relation to period one. And I put to you again, if we approach this appeal on the footing, subject which I appreciate may be subject to debate later on, but not before us, that breach of license conditions is an act fautif, why is it not necessarily also the case that trading without a license, which is the more egregious form of unlawful activity, is also an act fautif?
Well, my lord, in my submission, one can't make that leap. There's no. We know that the Court of Appeal trenchantly took the view that operating without a license would not would not give rise to foot in relation to Emtel. And I'll take you in a moment to that part of the judgment of the Court of Appeal.
All right, yeah, thank you.
In my submission, it's not enough simply to say, well, as a matter of logic, if the judge's conclusion about breach of license condition is right, then, as well, that's hard to square with what the Court of Appeal said. Emtel has to go further than that in front of the board, in my submission, in order to make good a case, not addressed by the judge or the Court of Appeal, and not accepted by the Court of Appeal, that trading without a license amounts to foot.
What about trading without a license offering a zero tariff that, if in effect, amounts to a cross-subsidy to the unfair disadvantage of Emtel?
Well, my lady, the same. The Court of Appeal was alive to all of those contentions, and the Court of Appeal said, no, we're not concerned with that. Essentially, we say, taking the position that Emtel's remedy lay, if it had one at all, under the doctrine that I referred to yesterday, that if Emtel can prove predatory pricing, and there's some material in the bundle about what that involves in Mauritius, or other conduct involving a long-lasting disturbance to the market, then it may have a claim under Article 1382. But questions which go to Cell Plus's exposure to action by the criminal authorities or by the regulator simply don't come into the picture. So very briefly, just to finish off with the judgment, if I may. At page 2, treble 7, the section entitled Emtel's Economic Loss starts. And that's just really to show you that where that section begins. Then taking it through to 2782, para 351. This is where we say the judge has lost sight of her own train of logic earlier, that her findings in relation to period 1 go to the counterfactual. So that's our that's our submission as to what that.
So sorry, could you just say that again? Because I'm looking at the section you've referred us to.
Yes.
Paragraph 330 refers back to sections of the judgment which cover both period 1 and period 2.
Yes, but again, one can't tell from that whether the judge is saying that the relevance of the evidence about period 1 is that it goes to what counterfactual should be applied in relation to what she's called the claim period.
Well, she does identify that an award should be made for period 1.
My lady, yes, and that's
which is consistent with her realising and appreciating that there were 2 claims for 2 different periods.
Well, it might be, or it might be consistent with her going wrong, as we say, and as the Court of Appeal said.
So you say it shows she's gone wrong, 351.
Yes. And she's departed from the logic which we say she expressed earlier, that the evidence about period 1 is relevant to the counterfactual for the claim for damages from breach of licence conditions. And then, just to round off with the judgment, if we can go through to 2785, para 360. You see again a very clear expression by the judge of the act fautif, which runs, the Court of Appeal said that what runs through the judgment as a leitmotif is that it's all about breach of licence conditions. And you see that again at 360. And we do submit there's a limit to how far one can take a theory that, oh, well, the judge must have impliedly had something else in mind in relation to period 1 as foot, and she must have intended to find that there was some other type of foot in period 1. When you take them together, in our submission, it would be doing far too much to read something like that into the judgment when she's been very clear about the basis on which she is finding liability.
The addendum at 2787, how did that come about?
My lady, there was quite a lot of argument about the appropriate approach to awards of interest. And I think that the addendum came about. This again falls into one of the important sets of untreated issues. There
was quite a lot of debate between the parties and the judge after the judgment had been handed down, you say?
Well, I think during the trial and after, and indeed quite a lot of the grounds of appeal were directed to interest because, unsurprisingly, given the timescales involved.
But did anybody point out to the judge what you're saying after she handed down the judgment? Oh dear, you've accidentally at 3581 awarded damages for the period March to August 1996, and that's not part of the claim period.
My lady, I simply don't know, as it were, what procedural events resulted in the addendum. I think Mr. Moulin, has explained to me that he wrote to the court asking for a hearing. on questions of interest.
Right, but I think my lady's point would lead to your clients writing to the court and saying, oh, you've awarded damages for period 1. There was never a claim for damages for period 1.
Yes, although I'm not
that
sure.
happen?
Well, my lord, I don't know is the answer, but I'm not sure that that would be conventional. If the judge has handed down judgment, and we say has got it wrong in certain respects, you move to an
not
appeal.
she got it wrong. You say she failed. I think your wording was she failed to follow the logic of her earlier reasoning that what happened in period 1 was only relevant to the question of whether you start the counterfactual in September 1996 with Emtel at a market share of 100% or at the market share of what it actually had at the start of that period. And that, you say, is all that was claimed and all that the judge actually found, in which case there was an internal inconsistency in her judgment, which one might expect would be pointed out.
My lady, as a matter of fact, I don't know whether or not that happened. I can find out. Now, in our submission, if we're correct to characterise the judgment as we do, we say that that actually quite closely mirrored the submissions that Emtel made to the judge. And can I, with one eye on the time, show the board what we say about this by taking you to our case? At 3227. And if I can pick it up at paragraph 47. You see that Emtel's written closing submissions were structured into sections as follows. A, factual background. B, liability. C, causation. D, quantum. Certainly right to say, I won't take you to it now, but Emtel mentioned the facts in relation to period 1 under factual background. Then section B, liability, was divided into legal principles, breaches by MT and Cell Plus, and then breach by the authority, breach by the ministry. And since paragraph 49 of our case, section 2, you see we've set out some quotations there from Emtel's closing submissions.
I mean, obviously, I'll have to go away and study this, but the impression I had was that Emtel's case remained throughout the case that was supported by their expert witness, with 1 or 2 tweaks, and the expert witness, Mr. Forrest, in section 10 of his report, had clearly included a calculation of loss for period 1.
My lord, he had.
Yeah.
But what you see...
And sorry, just to make the point, the judge herself referred to in paragraph, I think it was 351. Yeah. Because the cross-reference there, by my calculation, is to page 5546 in the bundle, where one sees table 10.4 in Mr. Forrest's report. So I wasn't conscious that there'd been any abandonment in its closing submissions by Emtel of that case.
Well, my lord, it's not so much that there was an abandonment. We say that the Court of Appeal was right to say that, in fact, there was no pleaded case of any type of fault other than breach of licence conditions.
Right, okay.
And my lord, we say that's consistent.
Was that your case to the judge? Were you saying that they hadn't pleaded a case in relation to period 1?
Well, my lady, the argument in front of the judge we say, involved no contention by Emtel there had been some distinct type of foot in period 1 at all. And so there was nothing for us to respond to. We certainly said that in the Court of Appeal. Can I go then briefly to the judgment of the Court of Appeal in relation to period 1? And if I can pick it up at page 2848. So in the previous couple of pages, the Court of Appeal has set out the grounds of appeal in relation to what's now being dealt with, period 1, and at the top of 2848, the top paragraph, you see the Court of Appeal summarises the arguments that Emtel has been referring to in relation to period 1.
If one looks at 2847, we see what your grounds of appeal were. And ground 6 was that the judge was wrong to have found liability established for period 1 as she failed to take into account effectively the backdating of the license. Yeah. Secondly, she was wrong to have found, as a matter of fact, that they started commercial activities in March 1996. And finally, she was wrong to find that the loss claimed for that period was direct et certain. So the point you're now making doesn't seem to have been a ground of appeal.
My Lord, no, although the Court of Appeal entertained argument on it, and as we'll see, it came to feature in the ratio. And it's not one of Emtel's grounds of appeal to the board that the Court of Appeal was wrong in that respect. But we see from 2848 in the top paragraph that the Court of Appeal is succinctly summarising the arguments that Emtel now relies on. And then in the middle of the page, just below the middle, it was submitted by counsel for Celplus that this first act of unfair competition in respect of the unlawful market entry was never part of Emtel's case for establishing liability against the appellant. Emtel's case was based on the breach of licence conditions, which involved the interconnection condition and the no subsidy condition, which were said to be part of the licence conditions. And the Court of Appeal then moves on in our submission correctly to say that the act fautif, which the judge has found to be established, was the breach of condition. And then moving over to 2849, the analysis of the Court of Appeal starts really under the italicised para 277 at the top. And you say that, and one sees that the Court of Appeal say that although at paragraph 72 the learned judge stated that Celplus started its commercial services before it obtained its licence, she never made any finding of fault pursuant to Article 1382 based on any unlawful and unlicensed mobile phone services provided in that period. Then the next paragraph is the backdating point, the retrospectivity point. And then the next paragraph is the pleading point. The Court of Appeal says a close examination of the statement of claim shows Emtel's cause of action in tort wasn't founded on the alleged unlawful market entry. Although there are some factual averments in respect to the commercial activities, the claim is founded on a breach of the conditions prohibiting cross-subsidy.
If I may say so, that just seems to be a misreading of the statement of claim,
Well, my lord,
where I think it's paragraph 11.1 certainly pleads entry without license, and paragraph 17 says, and that's an act with vote.
my lord, I'm not sure that paragraph 17 says that there is fault in entering the market without a license.
I thought it referred back generally. I might have misremembered, in which case I apologise, but
My lord, Mr. Danji points out to me that if one looks at page 15, para 12.3,
first of all, I was looking at 11.1 on
Yes.
page 14.
yes, 11.1 appears to be a particular, if you like, of the allegation made at 11. But certainly, please, we obviously accept facts which are relevant to period 1 and to what Emtel now says is its case in relation to period 1.
Right, and I don't think I did misremember. 17 is page 18. That's a general averment that the actions, i.e. those set out in this document, constitute vote. I wouldn't have thought there's very much doubt about it.
Well, my lord, I'll leave the pleadings if I may, because
All right, yes,
I'll need to.
the entry point for it was this passage in the judgment of the Court of Appeal 2849.
Yes.
Where it seems to me that they've simply misunderstood the statement of claim. Let's not take up more time on it unless there's anything more that you wanted to say about it.
My lord, I think that's all I can say on the pleading point.
Can I just ask you about a related point? On 2848, the first paragraph sets out Emtel's argument, and we see the last sentence makes the point which Lady Rose made a few minutes ago, that the backdating didn't approve a zero tariff. Now, the Court of Appeal deal with the issue of the effectiveness of the backdating, but do they deal anywhere with with that point that Emtel raised, that even if you accept the backdating was effective, the zero tariff wasn't approved? On the contrary, it was a breach of the backdated license.
Well, my lord, I think they deal with it compendiously at the foot of page 2850.
Well, it's dealing with in relation to criminal liability.
Yes, well, what Emtel says, as I understand it, is that there is fault because there is crime, and there is crime because section 17 is infringed.
Is that right? It's the sentence starts furthermore. It's dealt with the criminal offences, but then it goes on to say furthermore, the backdating of the licence didn't involve approval. That's not about criminal offences. That's about absence of approval.
And it refers to section 17 of the Act, which isn't a criminal provision.
Well, my lord, it is.
Is it? I thought criminal liability was round about section 40, but I may be mistaken.
Section 40 provides for criminal liability if you breach a term or condition imposed on you in your licence.
Yeah.
Section 41 says any other breach of any other provision of this Act is also criminal.
Yeah, but section 17, what's that concerned with?
3364. That's saying that tariffs and charges have to be approved.
Right.
So if you act without approval, then that's the entry point to criminal liability under section 40 and 41, isn't it?
Section 41, yeah. So the case theory is under section 17.4. you're not allowed to claim any rates, tariffs or charges which have not been approved.
Yep.
And then under section 41, if you do so, you have contravened a provision of the Act, and so you commit an offence.
Yes.
And what the Court of Appeal say at the foot of 2850, we say entirely significantly, starting in the third line of that bottom paragraph, we are not concerned in the present matter with the criminal liability of MT or Cellplus. Emtel had brought an action in tort, and for it to succeed, it would need to prove that the commercial activities constituted an act fautif within the purview of Article 1382. They go on to say, on account of the fact that it didn't hold a licence, but the Court of Appeal must there be saying that questions which go to the criminal exposure of Cellplus are nothing to the point when it comes to whether or not Emtel has a claim under Article 1382.
What it says, you would need to prove that the activities constituted an act fautif. You prove facts.
Yes.
How you categorise them isn't a matter of proof, but of legal analysis.
Well, my Lord, although the Court of Appeal didn't spell it out, we say that they were there expressing agreement with Cellplus' argument that a competitor can't invoke or rely on questions of breach of licence conditions, any other breach of the Act. Under the general jurisprudence, a competitor, there's well-established jurisprudence as to how a competitor might go about proving an act fautif in relation to concurrence déloyale.
Well, just getting back to the last sentence, what they don't go on to say after that sentence is that how they don't deal with the question not only as to whether there was retrospective approval for the start of a commercial service, but also whether there was any retrospective approval of the free calls. And for that, one would have thought one needed to show that the Telecoms Authority knew that the calls had been for free. Again, as we discussed yesterday, your client's in a bit of a bind, having said that there was actually no commercial service, then saying, oh, but if there was, it wasn't for free. So that seems to be missing from the Court of Appeal's judgment, isn't it?
Well, my lady, they don't expressly advert to it in that paragraph.
Yeah, well, you're
but they were obviously alive to it.
Very reluctant to imply any findings or conclusions of the trial judge, but yet you say that we should treat that as a compendious statement that they're actually saying that the licence, despite its terms, approves the zero tariff.
Yes, because they had, back at page 2848, they had specifically identified that Emtel was relying, amongst other things, on breach of Section 17. So it can hardly be thought as whether they'd forgotten about that when they came 2 pages later to express their conclusions. Now, I think then the board has my submissions.
We started late because other people went over.
I think the board has my submissions on what we've called the pleading point and the no act fautif point. Can I then turn to what we've called the retrospectivity point? I'll deal separately with the zero tariff argument and questions of Section 17. So leaving that to one side for the moment, in terms of a case based upon a contention that from March until the 5th of September, Cellplus was operating unlawfully because it didn't hold a licence. we submit as follows. Firstly, as the board has seen, the licence was backdated from the point of issue. There were then some adjustments to the date, but they're not relevant. As from the date that the licence was promulgated, on its face, it was backdated to cover the entirety of period 1. Emtel accepts, and accepted below, that the TA had the power to backdate the licence. And we advanced 2 propositions in relation to this. Firstly, the effect of the grant of the retrospective licence was to make it impossible for Emtel to establish that there was any unlawful or criminal conduct during period 1.
What, even if the trading was flagrantly in breach of the terms of the backdated licence?
My Lord, yes, if I can, that's a slightly refined question. At the moment, taking it at the level of...
I didn't mean it to be refined.
At the moment, taking it at the level of you shouldn't have been operating without a licence, full stop.
Okay.
We say the effect of the exercise of the power conferred by the Act is to make it impossible for Emtel to establish that there was any such unlawfulness during period 1. And so if Emtel's case was, as it seems to be, and to have been, that the alleged unlawfulness or criminality meant that there was faute, of course a proposition with which we also disagreed, then that case must fail. Now, firstly, we submit that where a statute confers on the licensing authority the power to grant a retrospective licence, that can only be so as to enable the licensing authority to achieve that very position, namely that by the exercise of the power, what was unlawful at the time it was done is rendered lawful. We submit that a licence is an instrument that renders lawful activities which would otherwise be unlawful.
So you say it can only be exercised so as to make the whole of the conduct lawful, is that right?
It makes lawful everything that you need a licence to do lawfully.
Even if it's subject to conditions?
My Lord, I'll come to that.
Okay.
Just a moment, you're just talking about them entering into the market at all.
Yes.
Okay.
Without a licence.
And you say, even if somebody has an accrued cause of action arising out of the unlawfulness, that cause of action vanishes once the licence is backdated.
Right, we do.
Yeah.
If the cause of action depends upon establishing that during the relevant period there was unlawfulness flowing from the lack of a licence.
I may be wrong. I have a vague recollection, maybe authority on this, perhaps in connection, domestic authority, perhaps to do with criminal liability.
Well, my Lord, we certainly cited a decision of the House of Lords called Howell and the Falmouth Boat Construction Company,
Right.
which I'll come to in a moment. But we say that you see essentially this reasoning being adopted by the House of Lords. But before I get to that, we say firstly, in a sense, if you like, why would the statute confer the power to make a licence retrospective, if not so as to enable the authority to render lawful that which was previously unlawful? One can't see any other point to the power being conferred.
And when you say power, such a power is conferred, are you meaning that's how you read the legislation, or is it express?
It's how you read the legislation.
I see. Right.
So there are 2 questions. What Howell says is essentially there are 2 questions. One is, as a matter of construction of the relevant legislation, does the relevant authority have the power in the first place? And in this case, that's common ground. Secondly, if it does the licence on a true construction have retrospective effect. And of course, it obviously did in our case. Now, obviously, with one eye on the time, can I deal with how, at least in the first instance, by taking you to the bit of our case where we deal with it? It's page 3232. Para 72. That, I hope, is a fair summary of the decision in Howell. It's pretty short, and it's fair to say that once the questions of construction have been canvassed, there was another question not relevant to us about whether the relevant license had to be in writing in that case. Once the questions of construction had been canvassed, essentially the House of Lords concluded, really as a matter of the obvious, without going into any reasoning, that accordingly, that which had been previously illegal was rendered legal, and so the defence of illegality failed.
And you say what's good for meeting a defence of illegality is good for establishing a defence to conduct which, but for the retrospective licence, would have been a tort.
Oh, we do.
By analogy.
Yes.
Right.
Now, can I deal briefly, relatedly, with the question, well, what about licence conditions? And if it said, well, the licence has been made to take effect from an earlier date than the date of its issue, and doesn't that also mean that all of the licence conditions are teleported back in time as well? And so that the licensee is now in trouble for having failed to comply with conditions which, as a matter of fact, weren't imposed on it at the time. And in my submission, that conclusion doesn't follow. And in this respect, a licensee is able to have his cake and eat it. Because we make this basic submission, that it's possible for legislation to confer on the relevant authority a power retrospectively to render lawful something which was unlawful at the time. But by reference to very basic principles of anti-retrospectivity, it's not possible for the legislation to confer on the authority a power to do something which renders unlawful something which was lawful at the time.
But it wasn't lawful at the time.
Well, my lord, it wasn't.
The starting point for this analysis is there was unlawful trading, and you rely on a retrospective licence making it lawful. So how is your analogy that statute can't render now unlawful something which was lawful at the time of any relevance to this analysis?
Well, my lord, no, I'm dealing here with the argument that, for example, that if we're right and the licence takes effect from 14th of March, 1st of January, that ergo we must have been in breach of the alleged no cross-subsidisation condition.
Yeah.
Well, it's more the condition as to what price you would charge.
Well, my lady, I'll deal with that separately, the zero tariff argument. I'll come to that.
I'm just looking at the leading speech in the Lords in Howell, which was given by Lord Normand. And I'm looking at page 3892. And you'll see that the main paragraph begins with the word "the next question." The next question is whether a license can be license under the order can be retrospective. And it says this is a question of construction. And then about a few more lines down, it would be a dangerous power to place in the hands of ministers and their officials to allow them, whenever they had power to license, to grant the license ex post facto. And then he says this, and a statutory power to license should not be construed as a power to authorize or ratify what has been done unless the special terms of the statutory provisions clearly warrant the construction. There are, however, in my opinion, sufficient indications that the legislation in question is a warrant for an order having retrospective effect. So, I mean, this is actually an authority against you.
Well, my lord, in my submission,
Unless you can take us to indications in the 1988 Act, which indicate that it envisages retrospective effect.
My lord, I can.
Right.
There may be a question of quite how I allocate my time, given that it hasn't been argued against me and it hasn't been argued in Emtel's case that the statute does not.
No, I know, but you've just you've just cited this authority.
Well, my lord, I know, but as it were, if I can, the Court of Appeal rightly observed that it hadn't been said that the Act didn't confer this power. It was common ground that it did.
Right.
Well, there's one, yes, but I'm anxious to hear what you have to say about the zero tariff point.
Yes, I'm happy to take my lords through the provisions of the Act, which we say do indeed show, if this needs to be shown, that the Act conferred the power to grant licenses retrospectively. But it'll take me a little time, and I've got quite some ground to cover yet.
Yes. Well, you fairly make the point that the contrary hasn't been argued.
My lord, yes, I'm very happy to reduce the points into a note, which I can submit.
I'm just not sure how far the concession went.
Yeah.
It may be that the concession was that you can include a start date on your license earlier than the date on which you sign the license. What you can't do is to bless or sanctify that which, when it was done, was unlawful.
No.
I thought that was the point and issue.
It is one, yeah.
Well, my lord, that depends on why it's said
In
to
which
be
case
unlawful.
we are back into Howell.
If it's said to be unlawful simply because there's an entry on the market that requires a license, then
Well, you've got your point that otherwise what's the point of being able to backdate it?
yes,
Yes.
which doesn't answer the construction point.
No.
But I had understood it from Emtel's case that Emtel doesn't take exception to the conclusion of the Court of Appeal that the TA had the power to do that, to issue a license which is backdated. Quite how far that takes me is another matter in relation to zero tariff. That's all. But in relation to the more basic question, whether it could be said that CellPlus committed a fault by entering onto the market without a license, full stop.
If you'd entered onto the market in March and charged an entirely reasonable tariff as per the conditions, and then it had been backdated, then we'd be in a very different case from the case that we're actually in.
Well, my lady, perhaps, although as I had understood it, it was said that we have done a number of things wrong. One is entering on the market at all, and another is offering free calls. And that one or other will do for Emtel's purposes.
Well, they might sound differently in damages.
They certainly might. And those are very fairly and squarely in the untreated issues. But my lord, I don't as well want to leave the loose end hanging. We do say that if one has to get into it, as a matter of construction, the Act does confer the power to grant a license retrospectively. The submissions are a little involved, and given the time that I've got left, I wonder if I could leave it that if the board does want to hear submissions on that, can I put them in the form of a note to which Mr. Brealey can then respond?
Yes, we better hear Mr. Brealey on that.
I'm content with that. I mean, we do say it's a question of construction. And we do say, as a matter of construction, all that happened when you backdated the license is the licensee doesn't steal 6 months. So it gets a license for 10 years, but it's been acting unlawfully for 6 months, and it's not entitled then to get 10 years plus 6 months. We've always said, as a matter of construction, it doesn't cure the fact, de facto, that they were operating without a license. And that's obviously without prejudice to our zero tariff point.
Yeah, yeah.
But we have said, as a matter of construction, backdating of the license only says you can't steal the 6 months. It doesn't cure the fact that you were operating in an unlawful manner, because providing mobile telephone services is a very, very serious issue. You can't have a free-for-all, and people invest on the basis that they're entitled to trade, and you just can't have a situation in Mauritius, or indeed in this country, where someone can just start a mobile phone company and then manage to get it backdated at a subsequent date. So we do say this Howell case is all about construction, and as one sees, my lord has referred to it, they construed the power to sanction because it was a wartime order, and you needed speed to mend the ships and repair the ships. So one can quite easily see why, in a claim which would seem to be an unmeritorious claim, I'm not paying you anything for the repairs because you weren't authorised. It was unmeritorious, but you could see on the construction of the order why they did what they did.
Yes. Well, if we were to, how long would you need to put in your argument on this, Mr. Casey?
My lord, perhaps 7 days.
Yes, and then if we give you 7 days, Mr. Brearley, to respond.
I'm obliged, thank you.
Very well.
I'm very grateful. Now, can I move then to the zero tariff argument, as it's been called? And I'd like to look, if I can, at firstly at Emtel's written case at page 3173.
You are going to have to be very quick on this, Mr. Casey.
My lord, yes, although Mr. Chetty and I have agreed that, as it were, our time is unitary between us, and at the moment, at least, I think he's content for me to
Very well.
carry on eating into his.
Very well.
So we see how Emtel puts his case at paras 39 to 41. And at 41, the plain and uncontested fact is that the backdating of the licence did not approve what the judge described as a zero tariff. For example, Cellplus could not, in March 97, charge a customer a zero tariff for a mobile to fixed call without breaching the terms of its licence. Now, we submit that, in fact, in March 97, Cellplus could indeed have done that. I'll come in a moment to how the Act works. But first, can I take the board to some guidance that Cellplus received from the TA in March 97, which addresses this very question. So this is the letter of the 31st of March, quite a long letter, reciting various modifications to the licence. It starts at page 1758.
But what year?
97.
What was the page number?
1758, my lady.
Yep.
The this is a letter to CellPlus. There was a separate line of correspondence going on with MT. For some reason, I don't know why, the letter referred to in paragraph 1 wasn't in evidence below. But it's apparent that CellPlus had written to the TA enclosing proposals for amending the licence.
Now, this is a modification as described in the Act, isn't it?
Well, my Lord, very probably.
Because it's happening after the original grant.
Yes.
So it's subject to all the Act's regime about modification,
Yes.
which your show was complied with, presumably.
Sorry, my Lord. Sorry, my Lord, I didn't catch the last question.
Yeah, are you going to show us that the modification conditions in the Act were complied with before this modification took effect?
Well, my Lord, I'm not, because I'm going to go, the letter ends with some guidance given by the TA. The modifications that are put into effect here, or that are referred to here, don't, I think, feature in this appeal. But I was going to take you to 1763. Paragraph 3 on that page, you are further informed as follows. And then B, Article 7. Now, Article 7 in CellPlus license is the article that deals with charging fees and tariffs. And you see it said that the tariffs or charges are defined in Section 2. We'll look at that in a moment. Tariffs are generally approved in principle as maximum tariffs, which an operator may charge for a given service. Any increase in such tariffs would therefore require the approval of the TA, and a revision downwards should be communicated to the TA prior to implementation. Now, in my submission, we'll come to the provisions of the Act, but we say that unsurprisingly, and the regulator has correctly interpreted and understood the effect of Section 17. But in my submission, it is significant that the regulator was of this view and gave this guidance. It was plainly in a good position to understand the workings of the Act, which obviously it essentially regulated its performance of its functions. If I can go then to the Act, starting at Section 2, 3356.
I'm so sorry, page?
3356.
Thank you.
So in Section 2, the interpretation section, we go down to rates. As rates means the rates applicable for the levy of any tariff or charge. And tariff or charge means a tariff or charge leviable in relation to the extent of use of a telecommunication service. So I think tariff or charge essentially means a tariff or charge payable per minute of call or per unit of time of call. And then the rate, as I understand it, is the sort of formula which is to be applied in order to work out what the tariff or charge is. Pausing here for a moment, we say that if you're going to say to your customers, for a certain period, let's say, you're entitled to free calls, absolutely free calls, then by definition you're not levying a tariff or charge in relation to the extent of use of a telecommunication service. You're saying, during this period, then for as long as you like, you can be on your phone. We won't be asking you for any money. And then that's really reflected in the wording of Section 17.4, 3364. This is the provision that we are said to have infringed. But it says no licensee shall claim any rates, tariffs or charges which have not been approved by the authority. And the short point is that if you're saying, either in the context of CellPlus was that you're in a period of friendly users and what it said was testing, or maybe once you're up and running in relation to some short-term special offer to try and drum up some interest in your product. If you're saying, well, for a period, you will have free calls, then you're not claiming any rates, tariffs, or charges which have not been approved. By definition, you're making no claim at all. So I do submit, I think there were some wry smiles yesterday when my learned friend adverted to the zero tariff argument and what we say about it. But in my submission, this is how this part of the Act works. And it is telling that that's precisely the guidance the TA gave to CellPlus. And not very surprising. If you're a mobile phone operator, then obviously you will want to have a New Year's offer where you're saying, sign up with us and you'll have a month free calls. And the idea that to do that, you have to go back to the regulator and ask it to approve that totally conventional commercial measure, in my submission, is unrealistic. And it's certainly not how the TA understood the position. So we do submit that actually there's nothing in what's been called the zero tariff argument.
But to determine whether a zero tariff falls within the notion of tariff in these provisions, ought one not to look at the functions of the authority, which are set out in section 5, page 3358, which are entirely general to control, monitor, inspect and regulate radio communication, telecommunication services. So it's not just to make sure that customers get the cheapest possible rates at a given point in time. It's to regulate the whole market. And of course, you can have predatory pricing, including through a zero tariff, to drive competitors out of the market. According to the functions of the authority, that's something that the authority should be concerned about, isn't it?
My Lord, entirely. The authority is
well, if that's right, that the authority should be concerned about people charging zero tariffs if it's having a wider effect on the market and potentially driving people out, why wouldn't one read the word tariff in section 17.4 to include zero tariff?
Well, my Lord, in my submission, that would be, in a sense, to allow the tail to wag the dog or to put the cart before the horse. If section 17 means what we say it plainly means, then the answer to the question is that obviously the regulator is not powerless to act. But if faced with such facts, and the regulator would say, I'm concerned that you've been offering free calls for too long, or under other terms which for some reason give me concerns, and I'm hereby proposing to modify your license under section 12 to add a condition saying that whatever it might say. So it's not that the regulator would be powerless to act unless 17.4 and 2 means something different to what the plain words say. But we submit that as well what one has to be driven by here in terms of whether or not these provisions which have penal force, if they're breached.
But section 17 operates on a theory of ex ante regulation, that you need positively to get approval for tariff rates. And if the function of the regulator includes regulation of the market generally, including, as I think you've accepted, a potential concern with predatory pricing, including at the limit case of zero tariffs, why isn't the theory of section 17, based as it is on ex ante regulation, sufficient also in support of the argument that the rates, tariffs or charges referred to include zero rates, tariffs or charges?
Well, my Lord, in my submission, that simply does too much violence to the words of section 17.4 and the definition of tariff or charge in section 2.
Yes, thank you.
If we go back to the actual condition in the licence, page 1642, it says the licensee will charge the subscribers appropriate fees as described in the third schedule hereto. All changes in call charges should receive the prior approval of the Telecommunications Authority. I mean, that seems to say that this licence, that the guidance that was given at the end of that letter in 97 doesn't apply at all to this licence, or certainly didn't apply when the licence was actually granted, because there it seems to be clearly saying these are the actual charges, not maximum charges, which, for the reasons my Lord Sales was just discussing, would be the logical thing for a regulator to do.
My lady, yes, although you then come back to our argument that the conditions are not teleported back in time to the 14th of March for the reasons I gave earlier. And just on that point, my lady, while we're in the licence, I do submit that there are some other indicia as to why that simply couldn't be the case. If we look at special condition number 10.
Could we have a page reference?
Sorry, my lord, yes, 1723.
Thank you.
You see an example of a sort of provision that one could use to test the theory of conditions being imposed retrospectively, as well as privileges being afforded retrospectively. So you see 10 requires a monthly list of new connection, cessation and changes in subscribers to be forwarded to the TA by the 5th of the ensuing month on a specified form. Well, on this theory that conditions are all made retroactively effective so that surplus can be placed in breach of them, could it be said when the TA granted the licence, well, here's your licence, I'm backdating it by 6 months, and you're in trouble because you haven't been giving us your monthly list of new connections during that period? In my submission, plainly not. And so that's what we say about the zero tariff argument as a separate argument, that in fact, at whatever point in time, offering free calls doesn't infringe Section 17(4). Just very briefly, on the point that my lady's adverted to that we also take in our case, namely, well, in any event, the TA knew that during period 1, Cellplus was offering free calls. And we do submit that's of significance. The position is that the TA knew that Cellplus was enlisting what it called friendly users. And the TA knew that the references are in our case.
That was on the basis of it not being concerned in commercial services at that point and simply testing a case that at the moment has been found against you.
My lady, yes, but what we submit is important is this. That before one gets to the question of quite how many friendly users there are, the TA knew that Cellplus was enlisting what were called friendly users and was offering them free calls. The TA never said, well, that's okay, but you'd better cap your friendly users at 500 or 750. So we submit that it is in fact the case, no matter how many friendly users we had, that the TA knew that they were having free calls, may not have known how many there were, but it knew they were having free calls and didn't demur. So if we do need to show approval by the TA as it were during period 1, then we find it there. The TA might have said, well, yes, okay, but we think you've moved beyond testing, and so you've got a different type of problem. But the fact is that the TA knew, the TA wasn't asking us how many friendly users do you have. It knew we were seeking them, and it knew that they were getting free calls.
But it thought that you were testing, so it was entitled to assume, well, that there'll be a handful, and it's not affecting the market. This is a test.
Well, my lord,
I mean, on the judge's findings of fact, you're seeking to rely on what appears to have been a misleading description of what you were doing to the TA.
Well, my Lord, there is an overarching point here, which is that we say that there was no exploration of any of these questions at trial because we say that the zero tariff argument wasn't pleaded. So
you're
one
trying
has
to overturn the findings of fact by the judge, basically, and other grounds of appeal that the Court of Appeal didn't deal with.
My lady, I'm not. I'm simply making the point that...
No, I mean, you're not doing that here,
No.
but I'm just saying your overall in your appeal is what you're trying to do.
Certainly our appeal to the Court of Appeal very much took issue with the contention that we went beyond testing in period 1. Can I move then to period 2? And can I again go to Emtel's case to see what it says about how the alleged licence conditions are said to have been imposed? Firstly, at page 3168. Para 16. This was in fact summarising part of Emtel's case on abuse. But what's important here is we see it says, the complaint is that we were saying the TA had acted ultra vires by imposing licence conditions in the letter of 5th September 96 and communicated publicly and by the press release of the same date. And then if we go to 3177, we're just taking it back to 3175, sorry, to show you the beginning of the relevant section. So 3175, section D begins. No subsidy conditions imposed on MT and Cell Plus. And then at para 57, having dealt above, at 55 with the sending of the licence and 56 with the sending of the letter dealing with exclusivity, 57 further on the same date, the TA imposed the no subsidy conditions on MT and Cell Plus. And in footnote 68 takes us to page 1732, which is the letter referred to back at para 16 we looked at a moment ago. And if I could ask us then to turn up page 1732. This is the letter which, on Emtel's case, results in the coming into being of additional licence conditions above and beyond those referred to in the licence itself. And in my submission, it's very hard to understand how one could say that this has that effect. The letter is to MT, albeit copied to Cell Plus. The first paragraph tells MT what MT should do, and the second paragraph informs MT that the authority will shortly appoint an auditor for certain purposes. And in my submission, if this is relied upon as it is, as the document or mechanism by which it said that the TA exercised its power under section 11.4 to create licence conditions, then that's really unworkable. Now, I'll turn in a moment to some more specific points about this, what's been referred to as a single document theory. But in my submission, the Court of Appeal was right in holding that the Act provides a comprehensive and careful code in relation to the imposition of licence conditions. Section 11.4 is mandatory in its effect, that any terms, conditions or restrictions imposed on the licensee shall be specified in the licence. And really, if Emtel were right that this letter has the effect it contends for, that would denude Section 11.4 of all meaning. More specifically, the language of the letter itself simply doesn't lend itself to this case theory. And the Court of Appeal rightly pointed out, and we've pointed out in our case, the dangers if Emtel were right. You'd have licensees being placed at risk of criminal liability, essentially for failing to infer from a document like this sent to its parent company, copy to it, or worse, in the case of the press release, not even sent to it, but finding its way into some newspapers and that sort of thing, I suppose. Not using imperative language in the way the other conditions do. Nonetheless, the licensee should be driven to infer, oh, tucked away in here somewhere is a condition of my license.
If my regulator told me he was going to appoint an auditor to make sure I wasn't cross-subsidising, would I think I was nonetheless perfectly free to cross-subsidise?
Well, my lord, no doubt you wouldn't. But that doesn't make it into a licence condition.
I see.
That comes back to the point I made yesterday. If the regulator says, I want to see you doing the following, that's a perfectly rational thing for the regulator to say, and it's a perfectly rational way to proceed. And you know that you're at risk if you don't, because the regulator that might then be unhappy with you and might escalate. But it doesn't. What's important for the reasons we've explained in our case here is that Emtel establishes that there was a condition of surplus license.
I mean, I can see that there may be cases where you have a number of documents and it's unclear from the documents whether they do relate to each other, whether there is a form of incorporation by reference into a license, and that a licensee who then is taxed with something in one of the other documents later on can say, well, I didn't appreciate it was a condition. But in this case, in the context in which the group of documents issued on the 5th of September came into existence, in fact, on the evidence, there wasn't any doubt that, in CellPlus's mind or MT's mind, that the no cross-subsidy and equal interconnection charges requirements were conditions of the license. And they may have been, you may have got to them from looking at the whole group of documents that were issued on the 5th of September, but everyone understood, including your clients, including the Privy Council in the previous case, that these were indeed conditions in the circumstances of this case.
My Lord, there's a caveat to that point about the Privy Council, which I'll come to in a moment.
All right.
But my Lord, in my submission, in terms of answering the question of substance, was this or was this not a condition of the licence, one gets nothing from the subjective understanding that CellPlus may have had at the time.
But surely you do. I mean, I would have thought that a licence is a document which falls to be construed according to ordinary principles of construction in its context and as a reasonable person would construe it. Now, why isn't CellPlus an exemplar of a reasonable person located in the specific context?
Well, my Lord, classically, when one's asking that sort of objective question, you don't look at the subjective state of mind of any of the protagonists.
Right. No.
You ask the question in the abstract. And my Lord,
But surely one would ask, how would a reasonable person located as this licensee was located have understood things? Why can't you look at how the licensee themselves understood it?
Well, my Lord, in my submission, as, let's say, with the question of construction of a contract, you wouldn't classically say, well, although this contract appears to mean one thing, I've heard subjective evidence that one of the parties understood it to mean something different, and so I will take that into account in construing the contract.
What if the evidence was that both parties understood it to have that meaning?
Well, my Lord, one then gets into questions of rectification and so
yes.
on. None of that was addressed here, and as I understand it, there was no evidence from the TA, from anyone who was in place at the time of the grant of the licence, about any of this. As I understand it, Mr. Makunlal had been intended to give evidence, but in the end wasn't able to.
But we have his letter to the Solicitor General at 1685, which makes it very clear that the intention was that these would be conditions of the licence, that this is what they have approved, he says. That includes the interconnection must be on the same terms as those offered to Emtel. There's going to be an independent auditor. The licence will be amended accordingly and finalised. Now, what you're suggesting is that between that 4th of September letter to the Solicitor General and the 5th of September, there was a change of policy in the authority not to make these conditions, but just to make them wishes or desires. Is that your case?
Well, my lady, firstly we say, looking at that document, it's not entirely clear when paragraph 2E says the draft licence, which was vetted, would be amended accordingly, whether accordingly refers to everything above or only some of the above. So A, for example, is about tariffs. B is about grant of exclusive rights. We don't know whether it's referring back to that or whether it's, we don't know whether, the draft licence wasn't in evidence. So we don't know whether things were taken out of it or put into it.
And this is a record, it looks like a record of the actual decision taken by the TA.
And it all happened. And what he here sets out took place.
Well, my Lord, what didn't happen, we say...
Well, except you say they didn't make it conditions of the licence.
Yes. And obviously it would have been terribly easy to do so. No great difficulty in typing into the special conditions 2 analogues of paragraph 7A and 7B of the press release. It's not as if that posed any particular obstacle.
But if everything else referred to in this decision letter was done, and the question is whether this bit was done in the way suggested, it's quite good evidence, isn't it, that the writer of the letter, who also signed the licence and the accompanying letter, thought he was implementing the decision which he'd just set out.
Well, my Lord, if the most that could be said in my submission would be this, if one puts that construction on this document, is that the TA had decided that there should be typed into the licence itself the 2 new conditions which one presumes for these purposes were not in the draft. But then for some reason that didn't happen. And in my submission, if that didn't happen, then for that reason, those do not become conditions of the licence. It may be that the TA, once it realises its error, would be able to say, oh, we intended that the things in the press release should also be in your licence. Here are the reasons why we're now going to modify your licence. We're proposing to modify your licence under Section 12. That didn't happen, but that can't change the underlying, even if the TA had intended to and by some slip, the licence had not been revised in the way suggested, we say that doesn't alter the fact that they didn't become license conditions. And can I just take one further point?
Sorry, that submission depends upon what documents you look to constitute the license. You accept that you can have a number of documents, provided that there's a sufficient incorporation by reference. So the question then seems to be, has there been a sufficient incorporation by reference? But speaking for myself, I'd have thought that the context in which a number of documents come into being may be highly relevant to determine whether people understood and ought reasonably to have understood that there was incorporation by reference across a number of documents. If there was, then they are license conditions.
My Lord, I entirely accept that if there was, on a true construction of the documents one's looking at, then yes, you would say, what's been achieved here is that the license includes the following. And classically, in a clear case, the license would say.
And so it's something that's bothering me, so I raise it so you can deal with it. I mean, we've looked at documentation which shows both Emtel saying, well, we need protection, no cross-subsidisation, same interconnectivity charges. We've seen documents from MT and Cell Plus positively proposing to the regulator, yes, we can see that there are these problems, we know you're going to be concerned about it, and here is what we can live with: equal interconnectivity, separate accounts, and no cross-subsidisation. So that's leading into the group of documents on the 5th of September. And then when we come out of it, we have further correspondence from Cell Plus asking for amendments to the licence, where they clearly, I thought, accepted that the particular requirements which were set out, both referred to in the letter, also set out more clearly in the press release, were licence conditions. So they both propose them as licence conditions, think they are licence conditions, get a group of documents on the 5th of September which from which you can distill that they are licence conditions, and in the press release they're referred to as licence conditions. Why wouldn't a reasonable person located as Cell Plus was not understand they are licence conditions?
Well, my Lord, in my submission, the position is, firstly, the letter that Cell Plus wrote, which prompted the letter we've just looked at with the modifications that came in March '97, and the letter that Cell Plus wrote wasn't in evidence, so we don't know what Cell Plus said to the TA. There was a letter from MT seeking some guidance. Your Lordship may remember there was an opinion appended to it.
Yeah, can you just help us with the page?
Yes,
if you're able to.
That document is at 1735, I'm told. Thank you.
I think.
No, that's coming after.
I think the opinion then is attached.
Oh, I see. Does the opinion come before?
Yes, I'm grateful. So the document at 1735 is MT's letter of the 22nd of October.
Yeah, asking for an amendment to the terms of the letter, paragraph 2.
Oh, right. Yes, sorry, that's what's following later on. Sorry, I thought you were going to tell us about what happened in the lead-up to the 5th of September. But
my Lord, I am. I am, but I was simply identifying the document
I'm sorry.
that my Lord referred to.
That's 1732.
Are we looking for the document in which MT says, please grant us a licence to Cell Plus? We realise there are problems. We'd be happy with a condition that we don't cross-subsidise and we have separate, we charge them the same interconnection fees. Is that the letter that we're looking for?
That's what I was thinking.
I'm so sorry, I misunderstood.
That's at 1695. 1695.
Yeah.
A letter on behalf of Cell Plus and MT. And the relevant page is 1698. a letter on behalf of both.
Yes. So in advance of the 5th of September, on my understanding, everyone appreciated that the interconnectivity charges and cross-subsidisation were issues of regulatory concern. Emtel were shouting it from the sidelines. Your clients had identified it and were putting forward solutions for that.
My Lord, let me put it this way. If the licence had contained a licence condition, let's say modelled on what was said here at page 1698, for example, then no doubt, given that history, CellPlus would have been in difficulties in, for example, seeking some judicial review of that decision.
Right. I'm putting it to you that they may be in difficulties in the appeal that you're presenting, which is to say, even though your own clients were suggesting that these would be licence conditions, even though there was a group of documents on the 5th of September in relation to the licence referring to them as licence conditions, they weren't, in fact, licence conditions.
Well, my Lord, we say that when you're trying to identify what are the licence conditions, you have to look within the four corners of the document that identifies itself as the licence. And if we're right about that, then whatever may have preceded that in terms of dialogue, decisions, mistakes, is not relevant to the objective question. If the document identifies itself and the document says the conditions of this licence are as follows, then for better or for worse, that's what the position is.
Is CellPlus still a wholly publicly owned entity?
My Lord, yes, I believe it is, yes.
There may be a matter of comment whether it's having proper regard to its responsibilities as a publicly owned entity in adopting the position that it is.
Well, my Lord, in my submission, CellPlus is entitled to dispute any allegations made against it which are properly arguable. It might or might not succeed, but like any other entity, it's entitled in substantial civil litigation to say, well, if you're basing your case on a premise that there was a condition in my licence, I say there wasn't.
And effectively, it's saying we put forward a proposal for a licence in these terms. Everybody, including us, thought we had a licence in these terms. Everybody, including us, thought that these terms were appropriate in the public interest. But if it was a slip-up, and in fact there was no such condition, then we're going to take advantage of that to avoid liability for what would otherwise be a breach of our responsibilities.
Well, my Lord, in my submission, that wouldn't be a fair way to characterise it. The position we say is that the analysis of what the licence does or doesn't contain is objective. The TA perfectly well has...
I appreciate it. It's not it's simply a matter of comment. It wouldn't affect the... if you're right on the law, then that's the legal answer.
My Lord, I understand. Can I make one further point, which I didn't make yesterday, in relation to this question of what a reasonable recipient of the relevant documents would have understood? I think the board has my points by reference to the language of the licence itself and the two provisions that we rely on there. But can I in fact go to the covering letter under which the licence was sent to the licensee, page 1715. And just to make the point very shortly, that obviously this, in terms of the analysis one's now undertaking, the document which encloses the licence says, please find enclosed the licence issued to your company. And we submit that's a further reason for saying that this theory of incorporation by reference is wrong and doesn't work. The licence itself, as we've seen, excludes it, and we say the covering letter too, plainly on an objective analysis saying to the licensee, your licence is what is enclosed, not, as it were, and brackets, and perhaps in another letter we're going to write to your parent. Now, my lords, my ladies, I think that really says what I can say on this question of licence conditions, in addition to the submissions I made yesterday. Can I just briefly touch on the question about exclusivity and why we say Emtel's theory about that doesn't work? If I can do that by reference to paragraph 117 of our case. Page 3243. So 116, we summarise Emtel's argument in relation to the exclusivity communications that we've seen. And then at 117, we make the point that something from the authority saying to a licensee, you will have a period of exclusivity during which we won't grant a license to anyone else in the relevant field, is not a term, condition or restriction of the license, and it's certainly not, in the language of section 11.4, a term, condition or restriction imposed on the licensee. It's advantageous. You don't impose something which is advantageous. And you can test it by saying, well, what if the dialogue had continued until 6 months after the grant of the license? And eventually the TA had been persuaded to say, okay, well, from now you can have 2 years of exclusivity. That's obviously a perfectly valuable assurance for the licensee to have, but it derives its force from the legitimate expectation that it generates. It doesn't need to be said, oh, well, it has to be a term of the license in some sense for it to be a benefit to you.
Is that really right? I mean, I would have thought that actually exclusivity of a license in a market like this is extremely commercially important, and you need, commercial operators need certainty both as to who has the license, i.e. the benefit of being able to trade in a particular market with exclusivity, and those who might otherwise want to trade in that market need to know that that right of exclusivity has been conferred. If one leaves it to the doctrine of legitimate expectations, where who knows whether the competitors would be bound by a legitimate expectation or could attack the enforcement of the legitimate expectation because of their own interests, whether that would do the trick that an exclusive license would do, conferring much more certainty, seems very questionable to me.
Well, my lord, certainly at this time the licenses were not in the public domain. So CellPlus's license was not open to inspection by putative competitors. So in my submission, in fact, when one...
Didn't CellPlus tell the world we've got an exclusive license? Otherwise, what's the point?
Well, so did the authority in the press release.
Well, my lord, indeed.
And
But
both sides told the world this is an exclusive license.
But that doesn't mean that it's a term of the license imposed on CellPlus within the meaning of Section 11.4.
Well, I mean, I think it's an interesting question. What would have happened if there's, take Emtel on its 7-year exclusivity, and it presumably bases its tariff on analysis of its cost stack and how much market share it's likely to get, and therefore what its tariff needs to be for it ultimately to be profitable. Now, those calculations will be based on it having exclusive access to the market for that. If after 6 months another analog mobile phone operator had been licensed, that would have knocked all those calculations out the window, because then its market share predictions may well be completely wrong. Now, you may say, well, there'd be an interesting question as to what remedy, what right it has to that exclusivity, and what remedy it could enforce against the authority.
My lady, yes, and we say that on that hypothetical, Emtel would be in precisely the same position whether the assurance of exclusivity were set out in the license itself, or whether it were set out in some other clear and unequivocal communication from the authority. In either case, Emtel would say, well, you gave me a clear and unambiguous assurance. You're now proposing to breach it, or you have breached it. That is contrary to my legitimate expectations, and I want the following remedies. And the remedies would be unaffected by the question of whether the communication is in the license or in some other sufficiently clear and unambiguous form. And we do say, you will have seen this from our case, that it's wrong to assimilate the license with a contract.
But whether that would be fault on the part of the authority, would that turn on whether it was in a condition of the license or not?
That I don't know. That I don't know. But in my submission, the primary remedy would not be, the primary remedy would be for an order, presumably of certiorari or some mandamus or something of that nature, maybe with some damages too. But in the public law context, the question as to whether that would be affected by whether the exclusivity is mentioned in the license or not is not something that's been raised at any point in these proceedings.
I mean, the real case that's being put against you is that whether or not it's exclusive is so fundamental to the very nature of the beast that to say, oh, well, because it's in a separate letter, it's not one of the terms of the license, is sort of kicking against the wind.
Well, my Lord, in my submission...
If I may, just to add to that, it's actually very important if something is a term of a license, because you then get the protection of Section 12 and Section 13.
Can't be taken away.
So I'm just looking at Section 11. I'm so sorry, I'm crossing across my Lord's question, but just that we're looking at the statutory provisions. Page 3360, someone applies for a license. So are you saying you can't apply for an exclusive license, you just apply for a license and hope to goodness that the authority doesn't give anyone else a license? Sure, I would have thought that you can apply for an exclusive license where you want the license to say this is an exclusive license, and if it does, then you get the benefit of Section 12 and Section 13 if there is any change to that exclusivity position. And if one looks at Section 11.4, which we have looked at several times, page 3361, the license shall specify any terms, conditions or restrictions which the authority may think fit to impose. Well, why wouldn't exclusivity be a term of the license? This is an exclusive license.
My Lord, I don't say that it couldn't be. I don't say there's something about exclusivity that means that you couldn't specify it in the license and thereby make it...
Right. I thought you were saying that.
No, I'm so sorry. No.
Right.
It perfectly well could be.
Okay.
But we say that significantly in this case, the document we looked at yesterday, page 1680, shows that the TA had decided that the licence would in fact not address exclusivity.
I thought you said at the beginning of your argument that it's an advantageous position, but it's not a term or condition that can be imposed on a licensee. That's what I wrote down.
Yes, my lady, there are 2 points. One is that on the facts of this case, and in the way that the CellPlus was given its promise of exclusivity, we say it was not and did not have to be a term of the licence in order to be perfectly valuable to CellPlus. The CellPlus received a clear and unambiguous assurance from the regulator that it wouldn't grant any other GSM licences for a period of 3 years. We say that having it in that form put CellPlus in precisely the same position it would have been in had the relevant assurance been spelt out in the licence itself. And there's another point, which is that even if it were recited in the licence, it wouldn't be a term, condition or restriction which the authority had imposed on CellPlus under section 11.4. In our submission, that language is aimed at, if you like, reading it a jus dem generis term, along with condition or restriction being imposed on the licensee, whereas something which is purely advantageous and doesn't really fit within that language.
But section 11.4 refers to terms as well.
Yes, to any terms which the authority may think to impose.
All right.
Yeah. But my lord,
Are you or are you not relying on the word impose to say that the entirely advantageous grant of exclusivity can't be a term of the licence?
in my submission, it can be a term of the licence, but if it were, it wouldn't be a term which one would say had been imposed, and because you simply don't speak about.
But section 11.4e is the provision which enables the authority to write things into a licence. I'm not sure that it has any other powers than that. I mean, it seems a very wide power, but if impose means these are only conditions which the licensee won't like, which seems to be your argument, that seems a very narrow reading of section 11.4.
Well, my lord, my primary argument is that section 11.4 doesn't come into it on the facts of this case, because the assurance of exclusivity was, and if it matters, was advisedly kept out of the licence.
Right, but I thought that all this submission about whether exclusivity can be a term of licence was a kind of prelude to, and when we come to the letter about exclusivity, clearly it wasn't a term of the licence because you can't have it as a term of the licence. But
No, I don't say that. And in fact, I think Emtel's licence, which is in the bundles, does record Emtel's exclusivity.
Yes, it does.
So I don't say there's something about exclusivity that means it couldn't be set out as a term of the licence. It would be an odd...
Well, just on that, I'm so sorry to take up time on this, but why then isn't it a term which is imposed on the licence? The licence shall specify, this is section 11.4e, a term which the authority may think it fit to impose, reading on the licence.
Well, my lord, the simple point is that we say that if you may have terms which are advantageous and which the licensee has asked for and received, and then terms which are onerous or disadvantageous, and as a matter of language, you would only refer to the latter as having been imposed.
Well, could it just mean insist on? We are deciding that there is going to be, as a term of this license, exclusivity. It's just, what it makes clear is that the decision-making power as to what goes into this license is that of the authority. It may well negotiate in the sense that if it doesn't, they may find it's not taken up.
Yes.
But impose may mean no more than insist upon.
Well, my lord, I think there's a limit to how far I can take the imposed point.
Sure. It doesn't say imposed on the licensee.
No.
No,
This
that's
is
true.
imposed.
That's true.
But do you accept, following up a point of my Lord Sales, that if it is included, as it was in Emtel's licence, that then the authority would have to go through the Section 12 procedure if it wanted, if it said to Emtel, look, you've actually done nothing with this licence, nobody's getting mobile phones, this is hopeless, we've got to appoint somebody else, would they have to then go through the Section 12 process?
My lady, they would.
Right.
That would be a modification to the licence.
Mr. Casey, you have pretty much used up Mr. Chetty's time now as well as your own.
My lord, I think I have.
There are two other counsel for the respondents also. So I dare say you may be able to sort matters out between yourselves, but I should draw to your attention how much time this is using up.
My lord, absolutely.
And indeed, the bench will have to be rather more disciplined also in their questioning.
Well, look, again, I think I've said what I intended to say about the single document theory, including that point about exclusivity. The only remaining ground of is the Henderson and Henderson abuse ground, which we've set out at page 3244 of our case. Can I deal with that this way? That ground of appeal has not even been mentioned in Emtel's case. If there's been a Henderson and Henderson abuse, or if there is to be a finding of a Henderson and Henderson abuse, there has to be a fact-sensitive and merits-based analysis. This already goes back to the JR proceedings. But Emtel never pleaded this, so none of those questions of abuse were considered below. The full suite of the JR proceedings documents are not before the board and weren't before the courts below because there was no pleaded Henderson abuse. And in my submission, really, one can let matters rest at that point. It's, we submit, several bridges too far to ask the board for the first time, none of the courts below having been asked to consider this, to say, please consider what happened at the JR stage and please conclude there's been a Henderson abuse. If I'm wrong about that, then we've said what we would say in our written case on the point.
Yes, thank you very much.
Thank you, my lords, my ladies.
Now, I think we must hear from Mr. Chetty, but can I suggest that when we adjourn for the short adjournment, counsel for the respondents perhaps get together and work out how we're going to use the available time. They do have an extra 18 minutes beyond the agreed time because the appellants went 18 minutes over, but we have to finish at 4 o'clock.
My Lord, may I
Yes,
say
Mr.
that
Chetty.
I'll try to restrict my submissions to 10 minutes.
Yes.
Should I start now?
Yes, certainly, Mr. Chetty.
My Lord, and my ladies, I will start. I will try to complete my submissions within 10 minutes, and I propose to make specific points rather than to go through everything that has been said yesterday and today. If I start with the period 1, we, in our written case, at paragraph 62 and 63, page 3201, we make the distinction between what are free calls and what are zero tariff. And we argue that the pleaded case of Emtel was always about free calls. The term zero tariff only came about an appeal, and in fact, the report of Mr. Forrest also speaks about free calls. And the inference we make is that free calls is totally permissible within the definition of the Act, whereas obviously zero tariff is a more complex issue and may or may not require approval from the authority. The second point I wish to make for the period one is that the Court of Appeal, in fact, comes to the conclusion that the license was backdated, and therefore the March to September period was a licensed period rather than an unlicensed period. And what the Court of Appeal says is that the learned judge failed to analyze the impact of that period being a licensed period with the alleged tortious acts of MT and Cell Plus. This is where the Court of Appeal said that the learned judge failed. And the Court of Appeal also referred to several instances to illustrate the point that in the mind of the learned judge, she, at all material times, was considering that period to be an unlicensed period. This is borne out as from page 2846 of the judgment of the Court of Appeal, where the Court of Appeal refers to several paragraphs towards the bottom of that page. The Court of Appeal refers to 4 instances, and the paragraphs of the trial judge's judgment, namely paragraph 67, paragraph 72, paragraph 351, and paragraph 351 twice, say that in the mind of the learned judge, she thought she was dealing with an unlicensed period.
But 351 expressly says the license was backdated to March.
Yes, that's the 4th one. And the Court of Appeal's conclusion is that failure to analyze that licensed period rather than unlicensed period with the alleged torts of MT and Cell Plus is a failing on the part of the learned judge. The difficulty that I have is that I have to cross out most of what I have written in order not to repeat the submissions of my learned friend, and of course not to take more time than I should. As regards the abuse of process point, very briefly, the Court of Appeal deals with that at page 2845. And they say that this has been hotly contested and was argued at length. It was a pivotal point, and therefore, in their mind, doesn't constitute an abuse of process or wasn't taken in their mind for the first time, as it is also a matter of mixed law and fact. And our submission is that the determination of the Court of Appeal at page 2845 is correct in that regard. Now, coming to the final part of my intervention regarding the conditions of the license, the first observation that I would like to make is that as regards MT, whether it has a license under the 1988 Act, Section 43, subsection 8, or whether it has a deemed license, as has been suggested, I humbly submit that it is a matter of fact that its license was never modified in order to incorporate any term as regards interconnection or as regards prohibition of cross-subsidization.
Forgive me, Mr. Chair, are you saying there was in fact a license that we just haven't seen?
It doesn't matter, with all due respect for my submission, whether there was a license or there was a deemed license. The fact of the matter is that the authority, if the proposition is that the authority imposed a condition on MT, which I readily agree that the authority has the power to impose a condition on MT being the parent company, the fact is that the license, at least for MT, the license existed before or was deemed to exist before. Therefore, the condition, the paragraph 7 conditions, comes after the license. The fact is that those conditions were never incorporated in MT's license. I'm saying that because then this immediately engages Section 12.
I don't think it's been contended that they were incorporated in MT's license. It said that the condition on MT was incorporated in CellPlus's license, and that's how the Privy Council looked at it before and said that there was power to do that.
This is the approach. The approach is that it is in CellPlus's license, but not in MT's license. Yes. So to that extent, Section 12, as far as MT is concerned, is engaged. And a second point I wish to make as regards the conditions is that the pleaded case of Emtel, if we look at paragraphs 7 and 9, the pleaded case of Emtel has always been that the genesis of the paragraph 7 conditions were directions issued by the minister. It is, according to their view, as a result of all those meetings and as a result of directions issued by the minister, by the parent minister, that those conditions came into existence. And at paragraph 299 of the judgment, the learned judge, the trial court, the learned judge found, as a matter of fact, there were no ministerial directions. And this has not been appealed against. And this is why the ministry, I believe the fourth respondent, the case against the ministry was dismissed. So the point I'm making is that the case was drafted by virtue of Section 11(3)(f), which lists out the 6 considerations to be taken into account when granting the license, and F being the ministerial directions which the authority has to take into account. Now, that substratum being found to be non-existent by the judgment of the learned judge, the present case, especially as from the appellate court up to now, the present case is now pitched by virtue of Section 11(4)(e), that is the wide discretion, as stated by the Privy Council in its earlier decision, the wide discretion of the authority to impose conditions. I'm saying that in the context, why? Because the second scenario involves only the authority analyzing the situation and deciding to give a license. The first scenario involves the authority with the minister and probably other persons, officers, in order to give a license. In the second scenario, firstly, we already have a situation where Emtel was given a license, and if we analyze Emtel's license with the license of CellPlus, we find a lot of similarities. Condition 9, which was referred yesterday in CellPlus's license, the equivalent is condition 7 in CellPlus's license, which is the condition prohibiting restriction of competition. The point I'm trying to make is that, firstly, in the second scenario where you have only the authority looking at the papers and deciding on the license, they have all the materials and they decide what to put in and what not to put in the license. And there is nothing new about restriction of competition because this exists already in the license of CellPlus, albeit the license of CellPlus was granted by the Department of Telecommunications in, I believe, 1988, earlier. So that it appears a bit odd if you have that condition, and that condition, it has been suggested that the paragraph 7, which more or less go along the same terms of that condition 9, paragraph 7 going more or less along the lines of condition 9, it is a refinement. Let us say it is a refinement of that condition 9. It improves that condition 9. It gives better clarity to that condition 9. It is a bit odd that you have condition 9 drafted by the authority, and then you have a separate document, albeit perhaps contemporaneously, putting conditions going in the same direction, achieving the same objective. What in my humble submission this also engage is that if we compare and contrast the paragraph 7 conditions with condition 9 of CellPlus's license, to a certain extent, it can arguably be said that it is a modification of that license, and to that extent, it engages again Section 12, and to that extent, when the Court of Appeal makes the finding that Section 12 is also engaged by virtue of the mandatory language of Section 12. The prerequisites of Section 12 should have been followed, and they make the finding that there was a modification of the license. I'll try to find the relevant part, and I will end my submissions and take questions if the board has questions for me.
Can I just, oh, sorry. We have up to questions.
Yes?
Yes. Can I just clarify whether you are accepting that it was possible for the conditions that were included, whatever they were, in CellPlus's license to be made binding on MT as conditions of CellPlus's license? If that is what happened, that is lawfully something that can happen.
The situation was that there was a parent company and a subsidiary company.
Yes.
And obviously the parent company had started all that process for the application of a license.
Yes.
So the parent company cannot say that I do not know, I wasn't aware of the applications, and I wasn't aware of the terms and conditions or the propositions I made. Obviously, we have to live with it. The license is given to the subsidiary, which is wholly owned. I fully accept that the conditions can be imposed on the parent company, especially if we are dealing with subsidization. I mean, it will be unheard of if the parent company were to advance huge sums of money to the subsidiary and then come and say that the subsidiary is doing something which is illegal, I'm not responsible for that. The parent company should be responsible for that. But where I do agree with the Court of Appeal, and I say that the Court of Appeal is right, is that there are procedures being given the regulatory framework as described by the Court of Appeal, the mandatory language, and the Court of Appeal lays emphasis on the possible criminal sanctions.
Yes, so just your arguments are broadly the same as Cell Plus's arguments, rather than being some separate argument because you're MT, not Cell Plus. Is that a fair summary?
Yeah.
Yes.
But I do agree that the authority had the power to impose conditions, and that conditions would be enforceable against MT, provided the steps of the law are duly followed. And this is where we argued on behalf of MT in the court below, because that is the position in law. Emtel's case against MT can only be possible in tort by way of vicarious liability as opposed to direct tortfeasor. And may I say that as regards the period 1, I have some difficulty to find where the direct tort of MT would lie as regards period 1 as submitted by Emtel. MT may be vicarious liable for period 1, but not as a direct tortfeasor.
We're going to have to adjourn in a moment, Mr. Chetty, but I wonder if the reference you were looking for to the Court of Appeal might have been page 2835. Where they say that the learned judge failed to address her mind to the failure to comply with Section 12. In the present matter, Cell Plus was already the holder of a license under the 1988 Act when it was decided that 2 further conditions, as published in the press communique, should be imposed. The license was never modified in order to include these additional conditions.
Yeah, but it was more precisely page 2837. 2837. The penultimate paragraph. Where they say, as from line 4, Cell Plus was already the holder of a license when TA decided to impose the 2 additional conditions. I thank you.
Yes, well, thank you very much, Mr. Chetty. We'll adjourn now and resume at 2 o'clock.